Hi, my name is Stephen Groden, and today I'm going to discuss something that comes up in law many times, and the title is Ignorance and Mistake, and how it can affect whether someone is actually guilty of a crime. Going through this topic, it's covered in Chapter 3 of our textbook, and it basically goes through the reasons and the intent of whether or not you knowingly committed a crime. So what are ignorance and mistake? We'll start with the basics. In criminal law, when we talk about ignorance or mistake, we're usually talking about someone not knowing something, either the facts of a situation or the law itself when they commit some sort of crime. It doesn't really work all the time. It very rarely actually does it work in a court case, but it is a possible defense. The law looks at whether the mistake was reasonable and what kind of mistake it was. There's two main types: mistake of fact and mistake of law. I'll go through mistake of fact first. So this happens when someone gets the facts wrong. Okay, that's why it's called mistake of fact. So it's usually a misunderstanding. They didn't have any ill intent or mens rea, which is basically the intent to commit something. And so basically, with the mistake of fact, as an example, you could say you walked into a store and you had a jacket, or you went into an airport and you had luggage. Well, if you see a jacket or luggage that matches what you owned and you grabbed it and left, you might get arrested for theft. But the fact is, it was not done in ill will, and you made the mistake. And that's mistake of facts. So that can be a very valid defense when it comes to a situation like that. The mistake of law is a little more difficult to prove. To say that you didn't know you were committing a crime, but you willfully did what you did. So when someone says, I didn't know what I did was illegal, maybe someone, could get away with that depending on what they did. There's ridiculous laws in some states. In Texas, it's illegal to sell or buy an eye from a living person. That sounds just absurd, but it's written. In Alaska, it's against the law to give moose alcohol. Not sure why that is written, but it must have been something that they used to do on a regular basis. So it's just strange situations at times, but that's how the law is interpreted sometimes. It's just very broad and open, and people, might interpret it a certain way. Another example, which we read in the book, a real case, Cheek versus United States. This was a real life case that was about tax evasion. And Cheek was charged with tax evasion, but he said he did not believe he was committing a crime at the time based on what he read, and also the tax laws didn't apply to him. Now, we know you have to file taxes. That's something that everybody probably should know, but according to what he read, and I think even some attorneys that he spoke with, he felt as if he did not have to. So the Supreme Court basically said if the law requires willfulness, in other words, knowingly breaking the law, then an honest belief that he was completely wrong might be a defense. So, it could work sometimes. Sometimes it can't. It just has to be reasonable. Why all this matters, the justice system has these laws in place and defenses in place for situations like this. I don't think they want to lock up everybody that does something silly or just off cuff, but it provides a balance of accountability and fairness, which is a big part of criminal law. So to wrap this up, basically, a mistake of fact can sometimes be a defense. It's honest, reasonable, and it shows that they didn't have any intent, to commit a criminal act. Mistake of law is probably not a very good defense unless the law was so unclear or broad that it just simply didn't, you just couldn't have possibly known. But thank you so much. I appreciate you paying attention to the video, and hopefully you learned something today. Thank you.